so she would agree to report as frequently as necessary on that. She would be able to obtain transportation to Larned once the bed becomes available. But in the meantime, she would be able to attend mental health treatment services through the Mental Health Association, so that she would actually be receiving some mental health treatment while awaiting a opening in Larned to go in for full competency restoration.
All right, so on the 24 CR 524, that would be a motion to revoke probation, would it not, Mr. Bauer?
Your Honor, I have 22 CR 458 for revocation.
I'm sorry. That's the
I'm
one.
not seeing it.
Okay, I turned it around. I'm sorry. It is the 458. Motion to revoke probation. And that's on a harassment by telephone. She was sentenced just October 2nd of 24. And then on this other one, the 24 case, that is still pending as status control on violation of a protection order. But Mr. Andrews, as you were saying, that we've already had an order finding her incompetent and sending her for further evaluation and treatment at Larned State Hospital. Would you agree with that?
Yes, Your Honor. And they have not had an opening at Larned State Hospital yet, so no efforts have been made towards competency restoration.
All right, Mr. Regier, what is the state's position on all of this?
Your Honor, the state is in agreement insofar as setting this matter over is concerned, that based off of the state's understanding of the statutory framework and the prior orders entered in both cases insofar as the issue of competency is concerned. On the issue of bond modification, the state would adamantly oppose any modifications in this matter. Pursuant to the information in the 2024 case, it appears to allege an occurrence date on July 11th, 2024, specifically refers to the other case, Butler County District Court 24 CR 458, specifically, quote, issued as a bond as a condition bond in Butler County District Court case number 24 CR 458. It would appear that the alleged occurrence date in count 1 in the 2024 case is prior to the date of sentencing pursuant to the October 31st, 2024 journal entry in the 2022 case. Thus, in the request for revocation in the 2022 case, it does appear to include a number of allegations that the state considers quite concerning. Additionally, it is the state's understanding that this is a defendant with at least 16 prior failures to appear, so the state will be adamantly opposing any modifications to the court's prior orders insofar as the issue of bond is concerned.
Mr. Andrews, your client has had her hand up for a while. Do you want to address the court or your attorney, Miss Huerta?
MHA and South Central Mental Health actually offer outpatient restoration therapy. I was going to see if we could maybe make a motion to be able to do that in the interim. Since it's taking so long for the Larned, they offer the outpatient restoration, competency restoration. I was going to see if maybe I can make an inquiry for us to be able to put a motion in to be able to do that instead. So that way I'm not just sitting here doing nothing.
Well, I think that goes hand in hand with what your attorney has asked, because if you were to be released on bond, as he was talking, then you would most likely need the services you're talking about under the current order. But what are you getting any kind of mental health visitors at all while you're in custody?
No, I don't get any of that. That's why I was going to see if maybe I could just OR out and do the restoration therapy as like a bond condition.
Is the jailer there by chance?
There's a guy here, Mr. Gorman.
I'm here, Your Honor.
Thank you. So Deputy Gorman, is she able to get any kind of mental health services while she's in custody?
I believe they keep their medical care pretty separate from us for HIPAA reasons, but I believe they are able to request access to speak to someone through Zoom, but it's limited.
Well, yeah, we're always troubled. I think everyone involved in this system is always troubled when a person is diagnosed to have a mental issue and that they need by statute to go to the state security hospital for further care, and we can't get them in there. Deputy, do you know what position in the list she's on to get in there?
I don't have that information handy with me right now. I can get that if you need me to.
The last time that I checked, I was 31 on the list. There was 31 people ahead of me, which puts it out for like another 6 months. So I just personally feel that it would be more feasible and better for me to be out so I can do the outpatient care with my my social worker, Lachelle, because she's the one that takes me everywhere and she takes me out to do activities so I can actually have involvement in the community that's actually proactive and productive for me and my mental disorder.
And Your Honor,
Deputy or Mr. Regier?
Your Honor, if the state may be heard briefly on that issue.
Yes, go ahead.
At least as recently as Friday or last week, it is the state's understanding that this is a defendant who is currently 21 on the list.
21 on the list. Well, they certainly do not put priority to the ones that are in jail on criminal charges as opposed to the ones that are in there on protective custody, as I understand it. But we do have a serious issue with Miss Huerta not appearing, as the state has pointed out. I do have concern that she's may or may not be getting the mental health she needs. I know that some, as the deputy said, there are some services that could occur, at least on a limited basis. But Miss Huerta, you're saying you're not getting any mental health services?
No, and it's really limited. Like whenever you do the Zoom meeting, they're not really able to do the things that I'm able to do with Lachelle on the outside at MHA, at Mental Health Association.
Well, I'm sure that's true.
What if I were to agree to GPS monitoring and then you could just OR me out so that way I could go to my outpatient therapy at MHA? Because I attend groups there. I go to group twice a week there. And then either Lachelle or Christine picks me up for the groups. And then Lachelle also does extra activities with me. Like she tries to get me in as many counseling as I can, or we go to like the library or something just to do an activity to keep me occupied. So that way I'm less likely to want to use drugs and less likely to be in a position where I have too much free time, so where I could get in trouble, basically. She tries to occupy my time as much as possible. So that way it's stimulating for me mentally to the things that are going to be positive for me to guide me to a better state of mental health, basically.
Well, I am going to need Mr. Andrews, some kind of mental health proposal from the mental health folks, if they really will support what she's saying.
Your Honor, I could tell you, I could tell you this much at least for that I know for a fact, which is that South Central Mental Health does do outpatient competency restoration, because I did have a case in which my client was not in custody and was found to be incompetent. It was through municipal court, and they did competency restoration. And it was very effective. So I mean, they successfully restored his competency, and we were able to resolve the case. That was South Central Mental Health Association. My understanding is that Miss Huerta would be looking to do.
I can go to South Central Mental Health. I've been a client there before, and
Hold on, let your attorney finish.
Okay, sorry, ma'am.
If if Miss Huerta can do it through South Central Mental Health, Chelsea Wynn is who performed the competency evaluation. At least one of them. She may not have done the most recent one actually, but she's familiar with Miss Huerta. She is the one who did the competency restoration in my other case. So I do know that South Central Mental Health can do outpatient.
All right, let's talk about that. This hearing involving defendant Miss Huerta was a complex mix of legal structure, mental health logistics, and sheer human effort to navigate a difficult system. Presided over by Judge Webster, we watched a courtroom try its best to make sense of a very real problem. What do you do when someone is legally incompetent to proceed? But there's no available bed in the state hospital to help restore that competency. Miss Huerta, who has already been deemed incompetent, is sitting in jail, essentially waiting for a spot at Larned State Hospital and, as of the hearing, she's 21st on the list. She stated that could mean another 6 months behind bars without receiving the care she needs. That's not ideal for anyone. Judge Webster's handling of the situation was as fair as you'd hope for. He listened carefully to everyone: attorneys, the state, the deputy, and most importantly, the defendant herself. He acknowledged how troubling it is when a person with a diagnosed mental illness is left waiting for treatment because of a backlog, yet must still navigate the criminal justice system. The judge was clearly open to a creative solution but insisted on concrete support from mental health providers before approving anything. That's a measured approach, open-minded, but not careless. Miss Huerta, for her part, came across as articulate and earnest. She spoke up respectfully, explaining her experience at the jail, limited mental health access, and made a sincere case for being released under GPS monitoring so she could attend outpatient competency restoration therapy with MH or South Central Mental Health. She explained her weekly routine with social workers, group therapy, even extra community activities like library visits, all designed to help her stay focused and stable. She wasn't evasive or combative, just someone trying to advocate for it herself within a complicated system. That said, her long history of failing to appear was also a serious concern noted by the state, and rightfully so. The attorneys brought a range of information to the table. Mr. Andrews was well prepared and ready to outline alternative treatment options, referencing a past client who successfully completed outpatient restoration through South Central Mental Health. The state, represented by Mr. Regier, agreed to continue the case but firmly opposed any bond modification, citing the seriousness of the violations and a track record of non-compliance. There was even a brief moment of community teamwork when a deputy was called in to clarify what kind of mental health services the jail could, or, more accurately, couldn't provide. What stood out here wasn't courtroom drama or fiery arguments. It was the quiet recognition that a backlog in one system can stall progress in another. Everyone, including the judge, recognized the imperfections. This wasn't about denying responsibility or ignoring risks. It was about making sure someone who needed mental health care didn't slip further through the cracks. We'll have to see what proposal Mr. Andrews submits from the mental health professionals. But this hearing was a good reminder that real justice sometimes requires patience, paperwork, and persistence. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below.